Hello and welcome to this webinar on incorporation and bylaws for community land trusts. So just as a quick disclaimer, this webinar does not constitute legal advice, and you should also note that the precise incorporation and bylaw requirements vary based on what legislation you're incorporating under, which I'll talk about a bit more later, although the broad strokes are generally pretty consistent across the country. So I'm going to talk first about incorporating your community land trust. What is incorporation? It entails forming a legal entity. The purpose of this is to enable the corporation rather than an individual to sign contracts and bear responsibilities. And it enables the corporation to hold and protect assets, which is, of course, very important for a CLT. Most funding opportunities are only open to incorporated nonprofits, so this is a really important step at an early stage. When should you incorporate? As a rule of thumb, it's a good idea to incorporate as soon as you have a general idea of what your CLT will do and you have at least a few people willing to support the organization as initial directors. In some provinces, including Ontario, you can incorporate before you even establish your bylaws, although there's a requirement that you submit your bylaws within a given amount of time. But in other provinces, including BC, you need to submit your bylaws when you file for incorporation. So you will be needing to make some kind of key, at least preliminary decisions prior to incorporating. If your CLT is not being sponsored or incubated by an existing group or nonprofit, you will need to incorporate prior to applying for grants. And it's also worth noting that some grants require applicants to have been operational for some minimum number of years. So it might be beneficial to kind of start this clock pretty early and incorporate as soon as you can to ensure you're eligible for as many grant opportunities as possible. So what is a CLT legally? CLTs are not usually legally trusts under the kind of legal definition of the term trust. There is no legislated definition for CLTs in Canada, and that means that you can incorporate your CLT under whatever legislation makes the most sense for your intended purposes. And in most cases, this means incorporating as a nonprofit, also called a not-for-profit, or as a society, which is kind of another word for nonprofit in particular jurisdictions. The steps that are involved in incorporating are not unique to CLTs, there's a lot of information out there about incorporating a nonprofit. Basically, all of this will apply to you, but we do recommend that you keep key aspects of the CLT model in mind throughout the process, just to help ensure that the decisions you're making are consistent with your CLT's values. So what can a CLT incorporate as? Again, they can incorporate typically as a not-for-profit. There is specific legislation in Saskatchewan and Ontario for incorporating as a nonprofit. In other provinces, this is enabled under companies or business corporation legislation. You have also the option to incorporate federally under CNCA, which I'll mention again in a moment, or you could incorporate provincially or territorially. In BC, Nova Scotia, and Alberta, and the territories, there's legislation for incorporating a society. This is not significantly different from other forms of nonprofit. Where a Society Act exists, CLTs typically incorporate under this rather than under the kind of broader Companies Act. And then in theory, a CLT could incorporate as a cooperative. Every province and territory has legislation for co-ops, but it's quite rare for CLTs to form as cooperatives, although CLT properties are sometimes operated as co-ops. So before you incorporate, there are a number of things that you need to do. The decisions that you'll need to make at this point will depend on what legislation you're incorporating under. Typically, it'll include your organization name, how many directors you're going to have, and your purpose. You might also need to indicate whether or not you intend to apply for charitable status. These decisions aren't quite set in stone at this point. Just about everything, including your name, can be changed at a later date, but it can be difficult and costly to make these changes, so it's best to avoid it wherever possible. You don't need to get a lawyer to incorporate, but it's a good idea to consult with a lawyer to assist with the incorporation process, especially if no one leading your CLT is familiar with it, and also to review your bylaws, particularly if you intend to make significant changes to your jurisdiction's standard bylaws. So these are some of the typical components of your articles of incorporation or letters patent, which is basically what you submit when you're applying for incorporation. So the name must be unique in your jurisdiction. There's usually a name search or name reservation process required as part of incorporating, and other naming rules might apply. So for instance, BC societies need to end their names in club, society, or association. You'll want to indicate the number of directors. Sometimes you can indicate either a fixed number or a minimum and maximum. You'll need to include the names and addresses of your incorporators. Those are the kind of founding board members. You'll need to indicate a registered office address that usually needs to be in the jurisdiction where you're incorporating. You need to specify your organization's purpose. This is typically a pretty short, about 2 to 3 sentences. And if you're going to be applying for a charitable status, you'll want to ensure that these purposes are compatible, or you'll have to go back and update them at a later point when you do get charitable status. And then in some cases, you'll need to indicate the classes of membership that you're creating. This is required if you're incorporating federally under the Canada Not-for-Profit Corporations Act. And so speaking of incorporating federally, what's the difference between federal and provincial nonprofit incorporation? This table is based on comparing CNCA, the federal incorporation legislation, to ONCA, which is the Ontario Not-for-Profit Corporations Act. There will be similar kind of differences between federal and provincial or territorial incorporation in other jurisdictions, but it might be a bit different. So federal incorporation is an option for you if you have an address anywhere in Canada and if you operate in one or more provinces or territories, whereas you can only incorporate provincially in Ontario if you have an address in Ontario. There are stricter financial review requirements under CNCA. Financial statements need to be filed annually by a certified public accountant in most cases, whereas for provincially incorporated nonprofits, you don't need to file financial statements annually. There's a greater level of public information that you need to share as a federally incorporated nonprofit. And then under CNCA, if your CLT or nonprofit dissolves, your assets need to go to a qualified donee, which includes a charity or municipality. Whereas if you incorporate under ONCA or most other provincial legislation, your assets can go to any public benefit corporation, which includes other kind of nonprofits. And here I have an overview of incorporation by jurisdiction, noting the province or territory, the key legislation you would typically incorporate under, how you file, some other guides that will help you with incorporating, the cost, and whether or not you need to have your bylaws drafted when you file for incorporation. And you can look through this and click on the links in the slides that we'll also be sharing. So, incorporation costs and resources. Relevant fees for incorporating, as we see in the previous table, range from $43 to $215. It's a pretty big range, but it's not a major cost overall. Just remember to factor in the fees for a name search or name reservation where that applies. You should also, like I said earlier, budget for legal advice. Costs will range depending on how much support you need, and they'll obviously be lower if you're going to be drafting your bylaws yourself, particularly if your bylaws closely follow the standard bylaws in your jurisdiction. If you're exploring charitable status, it's particularly recommended to get legal advice to support you in that process. And in another webinar, we talk about this in more detail. Prior to incorporating, you will not be eligible for most grants, but if you're working with an existing nonprofit, it's recommended to partner with them to apply for a small capacity building grant that will cover these early stage costs. And we have a number of funding opportunities listed on our website as well that you can explore. So once you incorporate, there are some things that you'll need to be doing regularly. So there are financial management requirements, which vary based on the legislation you incorporate under. There are annual filing requirements that will also vary, but might include filing financial statements, keeping an updated list of directors, in some cases paying an annual fee. And then there are requirements for annual meetings and kind of other ways of informing and engaging with your membership. In all cases, there will need to be some form of annual members meeting, and the specific rules for that will be set out in your bylaws. So getting into the bylaws. So to explain bylaws, it's good to position them among other governing documents. So the legislation you incorporate under takes precedence. Your bylaws will not apply legally if they conflict with that legislation. Similarly, your organization's policies are kind of secondary to the bylaws. Organizational bylaws set out the rules for operating and governing your corporation. Bylaws can be amended, but it's generally good practice to avoid being overly specific or prescriptive in your bylaws when it comes to things that need to be updated regularly. These other things can kind of be set out in policies which don't require the approval of the membership and can therefore be updated more easily and more regularly. It is also worth keeping in mind, though, that if you want members to have significant power in shaping your CLT, you might put more detail in the bylaws. And you can even structure your bylaws in a way that makes them difficult to update, which I'll talk about more later. So what's in your bylaws? There's a model bylaw under most of the different pieces of legislation that you can follow, and that shows kind of the basics of what's necessary to be compliant with that legislation. You might organize your bylaws differently, but all of these pieces will typically be included in some form. So membership, which includes membership classes and rights, members' meetings, board and other governance structures, so board composition, board allocation, board meeting procedures, management and financial matters, the process for amending bylaws, and in some cases you'll include an article on dissolution and distribution of property. So one thing to consider is to what extent you want to just adopt the standard or model bylaws versus customizing them. So if you adopt the standard bylaws, that's kind of the simplest approach. It might necessitate less legal advice. It's less time consuming, and it will limit the chances that your bylaws are conflicting with the legislation. It also enables you to learn from the experiences of other organizations that have really similar bylaws. And it means that if your bylaws are less comprehensive, you can set out more specifics in your policies or procedures, which are easier to amend. However, if you are customizing your bylaws, it can help your CLT work out in more detail how it wants to operate and be governed. It can limit the CLT's activities, but that can be a positive thing. So for instance, limiting board powers and protecting assets, which I'll speak to more later. And including important rules in your bylaws helps ensure that membership has a say on key decisions. So there's been some research underway by Sean Campbell, who also works with the Union Cooperative in Waterloo, about how CLTs can effectively lock in their assets. Bylaws are one tool that can be used to ensure perpetual community stewardship of CLT land and other assets. And this is really important because as time goes on, CLT assets could be put at risk because of misuse of assets or because of dissolution of the CLT. There are certain requirements upon dissolution based on the legislation you incorporate under, which I mentioned earlier. So it's more strict under CNCA and potentially less strict under most of the provincial or territorial legislation. But there are things that you can put in your bylaws to kind of shape what would happen if you did dissolve. Again, this research is fairly early stage, but some things that you can consider including is multiple membership classes and ensuring that fundamental changes require approval of all membership classes. You could incorporate board eligibility requirements to ensure that there is responsible stewardship of CLT assets. You can set term limits or stagger terms on the board to ensure that there isn't full turnover all at once and there's some stability on the board. You can restrict activities and powers of your CLT in its bylaws, and you can set higher voting thresholds or require a higher quorum for fundamental changes. So for certain kinds of motions at a members' meeting, you might say that a larger percentage of members need to be in favor. You can also restrict the admission of members during a period of proposed change. And you can prevent in your bylaws continuation or amalgamation or require that an asset lock applies after changes so that assets can't be immediately disposed of if there's some kind of major structural change. We have a list of a few different examples of CLT bylaws here under both ONCA and the BC Societies Act. And I want to end with a note on incorporating a decolonial perspective in your bylaws. So while it's not sufficient on its own, it can be good to detail your commitment to Indigenous rights and self-determination in your bylaws because it's kind of a concrete step towards adopting a decolonial perspective in your work. What this will look like should depend on your particular group's context and what Indigenous stakeholders in your community want, but it could include committing to transferring all of your land and other assets to a local First Nation or other Indigenous organization upon dissolution. It could include allocating specific board seats to Indigenous organizations or your local First Nation. And it could include broadening geographic requirements for membership to include members of your local First Nation in recognition of their ties to the land. That's the end of this webinar. Thanks to everyone who helped inform it. Thanks so much for watching.